Hello, YouTube. I'm Vince White. I'm an employment attorney. I apologize for all the mess behind me. YouTube user Pamaroon commented on it. Listen, everything's just torn apart right now. Excuse me. Shut down my New York City apartment. Got a ton of stuff here right now. Haven't really put things away yet. Did some laundry. That's not put away. It's a mess. So I apologize. Um, Also, quick. Well, I should say I'm an employment attorney. On this channel, we answer publicly posted questions for YouTube users, getting folks the answers they need from an employment attorney. I think I just annoyed the hell out of a commercial real estate agent, which I didn't mean to do. I feel really bad about it, but we had a Zoom to discuss my New York City office commercial lease. And I think that my thoughts on that lease and like what I wanted in an office and kind of the realities of like there's not that many high earning clients left in New York these days and stuff like that. There's not. New York's not super awesome right now. It's better than it has been. It's kind of on the mend right now, but it's not like super cool. I think those general notions and how they reflect on my thoughts on pricing may have annoyed her very much, which I feel bad about because I was trying to be friendly and pleasant, but also realities. It's unfortunate. Hopefully, I can repair that relationship. I guess. We have a question here from YouTube user SEK4110. And SEK4110 says, question, my lawyer told me that emotional damages or attorney's fees cannot be requested in a discrimination settlement case without going to trial. If there were emotional damages and, of course, attorney's fees, why would anyone want to settle without going to trial except a person who does not want to go to trial or who might be a poor witness on the stand? Okay, so let's take care of the attorney's fees first because I just don't agree. I think that you can absolutely capture emotional damages in settlement talks. I think that is based on the realities of our practice here and our negotiations and 14 years of doing this. That's just false. If an attorney is telling you that you can't capture some of the value of emotional damages in settlement talks in this field, I strenuously disagree, and I would, without throwing any shade at that attorney, because I'm not part of this conversation, so I don't know what that attorney actually said, but I would say that is simply false. Now, if that attorney said, hey, it's tough to capture the full value of emotional damages without going to trial, that statement is true. But if the statement was, hey, you can't get emotional damages in settlement, that statement is false. That is false on its face, in my opinion. Those are two different points, right? Like, you can definitely use emotional damages to substantiate some portion of a settlement demand. There's no question. We do it all the time, right? In fact, the most conservative attorney in our firm, conservative in terms of settlement valuations, routinely does it. I watch him do it, right? So even the most conservative attorney in the entirety of this firm, the least likely to push the boundaries in settlement, engages in including emotional damages awards in the settlement demands he configures, right? So can't agree with that. What your attorney may have been saying was you can't capture punitive damages. It's very difficult to capture, excuse me, allergy season, punitive damages from retaliation claims in settlements, and that is generally true. That is difficult. It can be done in certain situations. We have videos on how to use punitive damages as leverage for settlement purposes and things of that nature, but it is hard to capture punitive damages in settlement negotiations. Now on to attorney's fees. So in a settlement, and listen, every retainer is different, so I don't know how your retainer is structured or anything like that, but in 99 out of 100 retainers that I see, the attorneys take their contingent percentage, whatever it is, out of the sum they achieve for you in settlement, right? So you can characterize that sum as economic damages, emotional damages, punitive damages, attorney's fees, anything you want. But that's neither here nor there. They're going to get 40%, right? Excuse me. So when you're talking about attorney's fees and settlement, the defense is going to say, you can call them whatever you want. You want to call them attorney's fees? That's fine. And your attorney is going to say, you can call them whatever you want, but I'm still taking my percentage, right? Now, attorney's fees granted at trial, if you win at trial, that's a different story. Sometimes, right? And I'll tell you how we work it, and I have videos on this. If we win a grant of attorney's fees at trial, like we win a trial, we put in for our lodestar, which is the old word for it, our hourly rate paid for by the defendants, and we get, let's say we won a verdict of just $1 million for ease of math. And let's say our share was 40%, so $400,000, $1 million. And then we put in our lodestar, and we spent a lot of time, so the judge ends up granting us $300,000 in attorney's fees. Great. We would come to our client and say, hey, judge gave us $300,000 in attorney's fees. We are going to reduce our contingent percentage by that $300,000. So we will only be taking $100,000 of your $1 million, and we'll be pocketing the other $300,000 from the attorney's fees as paid by the defendants directly to us. This is not how every firm does this. This is something you need to pay attention to in your settlement agreements. Many firms, believe it or not, will seek to double up. They will take their contingent percentage. So, and I think this is, I don't know if I can say it's unethical, because the Bar Association has a monopoly on saying what is and is not ethical, and their thoughts count a lot more than mine when it comes to ethics for attorneys. But I can say it, to me, feels wrong. It feels a little bit immoral. Here's what some firms do. They'll say, okay, so I get 40% of what I won for you, so we get $400,000 on that $1 million hypothetical. And then the judge grants us $300,000 as attorney's fees. So we'll be pocketing $700,000 total, and you're getting $600,000 of the $1 million we won for you. You may have noticed the firm just earned more than the victim, the plaintiff. That would not fly in every jurisdiction, but is something that I have seen people do and get away with time and time and time again. And every time I see it, I know, one, that the plaintiff who agreed to that retainer agreement did not understand that was even an issue that they would need to think about in negotiating the retainer agreement. And two, it makes me so uncomfortable that the person who was wronged, the person who suffered, is making less money than the law firm. Listen, law firms put a lot of time and money in these cases, but I don't think you can earn more than the victim, right? I mean, that to me makes me very uncomfortable. And it is an issue in this industry. So SCK 4110, first things first, you better figure out what your deal is, right? In your retainer agreement, how are attorney's fees handled, right? It's a big question, right? Now, your question goes on. Why would anyone want to settle without going to trial, except a person who does not want to go to trial, who might be a poor witness on the stand? So there's a reason why the settlement rate is so high in this field. Generally speaking, there's no sure things in employment law. There's no guarantees. Any attorney who guarantees you almost anything in this field, any kind of outcome, or who tells you a case is a slam dunk or a sure thing, right? Anybody who uses language better than like, listen, I would risk my money on this case, or I think you have a solid claim, it's a winnable claim, a valuable claim. Like those are the kinds of qualified statements, accurate statements that I think can be made. But if somebody's giving you a probability, a guarantee, telling you it's a sure thing, a slam dunk, anything like that, just go ahead and report that attorney to the Bar Association, because that attorney is committing an ethical breach, in my opinion. It may or may not be an ethical breach in the views of your local bar association, whatever state or jurisdiction you're in. And I guess that's the Bar Association's purview, and they'll make that choice. But if they don't agree with me, they're wrong. That's a very bad thing for an attorney to do. So the reality is there's no sure things. And the reason why the settlement rate, I think it's less than 2% of cases, certainly, based on my experience, are going to actually go to trial. And often the cases that go to trial are the cases where there's a lot of uncertainty as to who will win. The most uncertain cases go to trial, right? So if you have a case, and let's say you have a case, and your attorney thinks you're very likely to win, and defense counsel thinks you're very likely to win, they're going to have a settlement negotiation where they probably arrive at a figure that reflects that you're very likely to win, right? Because your settlement is the valuation of your case hedged for risk. That's often where cases settle, when the case value has been maximized in terms of the settlement potential, right? And that's a fairly good deal for most plaintiffs. There's a lot that can go wrong in a case. The emotional harm, the stress, the anxiety, the trauma of going to trial, really, it's a lot. And as people are exposed to more and more of it, often you'll see people who are like positive they want to go to trial. I want my day in court. I want to testify. And they go to their deposition and they get 8 hours of the business. And they're like, take the deal right now. Get me out of here. This person is This person is a monster. You're like, yeah, this person does this every day of their life. They depose people professionally at the tune of like $1,600 an hour. They would not be earning $1,600 an hour if they were not incredibly good at deposing people, right? They're very good at this. You know what? Odds are you might not be very good at testifying because you may never have done it before, right? So somebody does it every day of their life and they're hyper compensated to be good at it. And if they're not good at it, they'll get replaced, both within their own firm or by another firm. Right, their defense client will go hire a different firm because, like, yo, that deposition attorney you gave me was hot trash, and I paid $600 an hour for that dude or woman, and they were not good. So it's a hyper competitive environment for defense counsel, and they get so many touches, so many repetitions over and over and over and over again. So a lot of times you'll have people who think they want their day in court. Who are like, why would anybody ever settle? I'm just going to tell my story, and then they get a little taste of what actual trial will look like, just a taste, just the deposition, right? And that case will be settled in about 48 hours. Happens both ways, right? Like, I'm not making fun of plaintiffs here. I'm not like, certainly you start deposing important decision makers at an employer. Often, depending on the importance of the decision maker, you'll get a settlement in advance of the deposition. Like, whoa. Hey, I see you've got our CEO scheduled, and as you know, I made a motion. The CEO is scheduled for deposition, and as you know, I made a motion to the court that you shouldn't be able to depose our CEO, but the court sided with you. So we're scheduled to go forward next week, and our current offer is $400,000. Would you take 450? No. You got to go check with your client. I don't. I have standing authority from my client. Well, would you take 475? No. Well, you got to check with your client. You're ethically bound. You got to go check with your client. Like, no. I have written authority from my client. I know what the number is that I would then take to my client. That ain't it. Well, what's the number? Oh, you don't get to know the number. That's not how any of this works. Well, I think we should involve your client. I'm sure you do. Yeah. I'm pretty good at involving my clients. My clients stay informed. You were at 475? Do you want to keep going? What's next? Right? And they might get to a number, they might not. But they'll be very motivated to not have the CEO deposed. right? In part because the CEO might know lots of things that might be uncovered, and they don't want that person being questioned for even unrelated reasons, or because the CEO is super important, right? Or they don't think the CEO is going to do well, or even they think the CEO might do great, but like they might lose their job because they exposed the CEO. They lost their motion to get the CEO out of the deposition. The CEO is going to be exposed to a very rough day of deposition, 8 hours minimum probably, and they're going to come out spitting mad at everybody involved in getting them deposed for the day. So, both sides of the aisle, when they get their first taste of what a trial might feel like, what a trial might look like, will often say, oh, no, I don't want this. This is not okay for me to be treated this way. This is horrible. And then when you start to understand that if you put on 5 minutes of a trial in front of a jury, that jury might listen to less than 2 minutes of that 5 minutes. I don't remember the study off the top of my head, but I think it's like 1 minute and 30 seconds of out of 5 minutes of testimony. It might even be out of 10 minutes. I don't know. Juries are wild. And I've shared this story many times, but like the biggest victory that I ever worked on, which I would not take, not going to take full credit. It's like, certainly I was just another attorney on this case, but well, because I'm feeling humbled today. That's not like me. When I had the chance to speak to the jury after, the jury was pretty upfront, like, oh, we hated your client and we hated your client a lot, but we hated opposing counsel more. So we found for you. It's like, opposing counsel was not present for any of the events of the case, right? You that has nothing to do with what actually happened here. You didn't decide the case. You decided a popularity contest between essentially me and opposing counsel, right? And I was a young, inexperienced goober of a loser, but friendly. And he was a sharp, experienced litigator who was mean, right? And you didn't like that. So millions of dollars changed hands. Stop and think about what that means. The merits did not matter. Even a little bit. Not at all. Not at all. Like, and yet millions of dollars changed hands. That should fill any plaintiff or defendant with dread. The defense counsel get paid either way, and the plaintiff's attorneys make it up in aggregate, right? Like, smallest plaintiff's attorney case list I've ever seen was like 40, 45 cases. Out of 40, 45 cases, you're going to break good most years, right? Or at least break even most years. Often you're going to see 80 cases per attorney, though, because in aggregate, if those cases are properly staffed and properly resourced, in aggregate, those cases will make that attorney lots of money. They might lose a few for crazy reasons that have nothing to do with the merits of the case, but in aggregate, often enough, if they're, doing a decent job, they're going to come out ahead. And so in aggregate, they'll come out way ahead, even though they lose a ton of money on the cases they lose, right? But that's in aggregate, right? It's easy for the attorneys to be like, yeah, roll the dice. We stand to win a lot more at trial. Let's go, right? That's often, I get criticized for that, where I'm like, yeah, you don't have to take the settlement. We can go. Like, let's go. And other attorneys in my firm will be like, yeah, so Vince, we'd really like you to go to trial. And maybe that's right for you. Maybe it's not. But think about the fact that Vince gets to do this a lot. And you have one. And so the amount of risk that you're thinking about embracing right now, it's quite a lot. And for Vince, it's quite a not, right? So that's a reality of the situation too. So it's easy for me to sit here and be like, yes, SEK 4110, we should go to trial. Let's risk it all. Let's make it happen, right? But often for plaintiffs, the bird in the hand, the guaranteed money, the ability to not be exposed to the horrors of trial, the ability to not be exposed to the randomness and risk of trial has tremendous value. And if you like the idea that there's only two reasons why you wouldn't want to go to trial, you don't want to go to trial or you're not a good witness. Those are not the only two reasons. That the reasons to not go to trial run the gamut of human experience. They are many, and I hate all of them because I would love every case to go to trial. But that's not what's good for our clients. So often, more often than not, almost always, but not always, cases tend to settle. And that's at the client's behest. And that's just the reality of the situation. Now, again, I just want to clarify earlier in your question, I don't agree that emotional damages cannot be captured in settlement talks. I think that is just patently false. At least some of your emotional damages. Some. And I discussed at length the attorney's fee issue, which you'll need to refer to your retainer agreement to see how those are being handled. And in the absence of any language about those or how those are handled, you may want to ask, because there's only two potential assumptions there. You get all the attorney's fees, and that is almost never the potential assumption in my experience of a law firm, or the firm gets all the attorney's fees. And that is very commonly the assumption of a law firm that does not have language in their retainer agreement dealing with how those attorney fees awards will be handled. Okay, so I would urge you to do your due diligence and understand what specifically is the lay of the land. It could be very important for you. Anyways, take care. I think this is coming out on Sunday, so happy Sunday, everybody. And I hope all is well. Bye. Oh, I have to say the things. Oh, first off, anybody who's got their own issues with attorney's fees with attorneys, I would love to hear about that down below. Talk about it. Or if you have thoughts on whether you should settle or not settle your case, I would love to hear that as well. I love to have these conversations. Now, if the video was helpful, I must tell you to like, subscribe, and comment down below. And further, I must urge you to share the channel so it can grow. I don't actually care if you do any of those things. I'm supposed to say these things. Also, listen, I get it. Give me the thumbs down. If you don't like it, fair enough. Fair enough. I deserve the thumbs down. Give it to me. Fair enough.